Hey everyone, thank you so much for having me here today. It's great to be presenting to you guys during Brain Injury Awareness Month. My name is Amanda Pearlstein. I'm an attorney at Disability Rights New York, which is the state protection and advocacy agency for people with disabilities. And I work in the PAT-B program, which is the protection and advocacy for people with TBI. So I've been working with individuals with traumatic brain injury for the last couple of years, helping with things like access to waiver services, housing, employment discrimination, things like that. But this is a relatively new issue to us, and one that has a huge impact that I think many people outside of the military community might not be aware of. It's an issue that I wasn't really aware of until we began investigating it. But it affects thousands of New York veterans who have traumatic brain injury, and it affects their family and their communities. And that's the issue of being other than honorably discharged for brain injury and how to get the discharge status upgraded. So I'm going to go into a lot of detail in this presentation about what happens, why it happens, and kind of that process for getting your status upgraded. And just in a quick note, I never served in the military, so I did plenty of thorough research for this presentation. I spoke to people at the Division of Veterans Services, but at the same time, there's a way things are supposed to work on paper and the way they say it works. And sometimes that's different from how it actually works. So if you're a service member or a former service member and you're watching this and thinking it's actually completely different, that's not how it worked for me, please let me know afterwards. We can discuss it in the Q&A because I definitely don't know everything about this issue and would love to learn more from somebody who has that lived experience. And that's going to be kind of the most important perspective here. Great, so I'm excited to get into this presentation. So I wanted to start off first by just sharing some numbers because I think people may not realize the full magnitude of what the number of people who are affected by traumatic brain injury in the military. You can see this chart that I got from the Department of Defense, and it tracks the number of traumatic brain injuries in service members, in US service members worldwide. So from 2000 to 2020, there were 430,720 service members who sustained a brain injury. And as you can see from the chart, the vast majority of these were mild. A mild TBI is essentially the same as a concussion. So just the definition of that medically is it's a confused or disoriented state following a head injury that lasts less than 24 hours. You might lose consciousness for up to 30 minutes or have memory loss that lasts less than 24 hours. And I think most people, both within the military and in civilian life, kind of tend to downplay concussions and think it's not serious. Most of us had a concussion as a kid, and it's kind of viewed as a thing that you just, okay, walk it off, you're going to be fine. And oftentimes you are, but kind of the science and the new developments with like the neuroscience of head injury has shown that even concussions can lead to long-lasting impact, especially if you have a series of concussions repeatedly. If you have seen the news about football players and CTE and how that can lead to dementia and very serious consequences that people weren't necessarily aware could happen from just having concussions. So that's the majority of cases. I have the numbers. We don't have the full numbers from 2020 yet. We only have it through the third quarter. But in 2019, over 20,000 US service members sustained a TBI. And again, most of those were mild, but 13% were moderate. The rest were considered severe or penetrating. Just again, more definition, penetrating TBI is what it sounds like. It's a projectile of some kind, a shell, something from a bomb or a bullet actually penetrates the skull and the brain matter. So that's obviously kind of the most serious type of injury. But if you have a traumatic brain injury that's classified as moderate or severe, that can also have, again, very serious lifelong impact that affects you after you return home from service. But so most of these injuries are mild TBI, and most service members who sustain a mild TBI are supposed to return to full duty within about 10 to 14 days. That's kind of the best protocol, is to get that kind of rest and then progressively return to active duty service. So, I mean, because there are risks, as I'm sure a lot of you know, of returning to duty too soon after you have a concussion or a mild TBI. It can lead to longer symptoms, more accidents, increased risk of getting more concussions, and issues with your performance, things like marksmanship and readiness for combat. So that is the recommended period is at 2 weeks. But again, sometimes people are hurried through that or feel kind of internally that they need to get better quicker to get back in fighting shape. So that people don't always take the time that they need. All right. I have put together this chart just showing over the past, over the past decade, the trends as far as TBI in the military. The number peaked in 2011 with 32,834 and has thankfully been on a downward trajectory ever since. So again, we don't have the full data for 2020, but you can see it's probably going to be lower than what we've seen in the past. But these numbers still mean that you have more and more people every year cumulatively returning from service with head injuries. And that goes back, there's Vietnam vets and people who served in the post 9/11 era, and then people who served in peacetime. TBI during military service doesn't have to be combat related. A lot of people get TBIs from training exercises, from sports accidents, car crashes, motorcycle crashes. And if that happens during your active service, and that counts as a TBI that was sustained in the military, it doesn't have to be a combat injury. But as far as combat injuries do go, 60% of US battle casualties come from the detonation of improvised explosive devices, or IEDs. These blasts can cause severe brain injury. And the reason we're seeing kind of more injuries from these kinds of combat situations is actually kind of a positive thing. Not that anybody should be injured, but that it means more people are surviving. They're surviving injuries that would have been fatal in the past. Thanks to modern technology, the armored vehicles, body armor, and better care in the field, better medical care. US service members are surviving in numbers that are much higher than in past conflicts. If you look at kind of the ratio of being wounded to being killed, in the war in Afghanistan, it's 7.4 to 1. I pulled these numbers from the Department of Defense as well. And that's compared to 1.7 to 1 in World War II. So nearly as many people killed as injured, and then 2.6 to 1 in the Vietnam War. So that's getting gradually better and better, the survival rate. And then the more lives are saved, the more people are returning from service with a traumatic brain injury. And then I just wanted to kind of add a quick note on diagnosing TBI in the military and its concurrence with post-traumatic stress disorder. There are a lot of co-occurring symptoms, as I'm sure you guys know, between traumatic brain injury and PTSD, fatigue, insomnia, anger, irritability. And that can make it hard to kind of tease those out and diagnose and treat separately. Also because there's evidence that TBI can increase the risk and severity of PTSD. And there's also the factor that if you've been through a combat situation in which you were injured, you're going to have that emotional trauma as well as that physical trauma, and those two things will continue to play off each other. So the chart for PTSD diagnoses in the military is probably similar to this. There's probably a lot of overlap. And that's important to keep in mind because, as we'll see later, both PTSD and TBI are considered as mitigating factors for behaviors that lead to other than honorable discharges. All right, so going into how TBI can lead to bad paper discharge, and bad paper is just the term for less than honorable discharges. So traumatic brain injuries can cause mood and behavioral changes. And again, this is not 100% of the time. Every person, every brain, and every injury is different, but what happens is commonly you'll see an increase in impulsive behavior, aggression, high risk behaviors. People who have TBI might also have higher rates of alcohol and drug abuse. And that can be because of kind of lowered inhibition, lowered impulse, but also self-medicating for trauma, for emotional and physical trauma, for kind of that experience of mourning what you've lost from having had this injury. So it's very understandable that a lot of people will turn to alcohol and drugs to medicate that. And what all this can kind of result in is getting in trouble with the military, and leads to behaviors like disobeying orders, getting into fights, using drugs, disappearing for days at a time. And these can all lead to these bad paper discharges. And what the government gradually came to realize is that this is totally unjust and unfair, because what they're doing is they're punishing people for manifestations of injuries that they sustained because they were serving this country and they were in their military service. So we're going to see in a few minutes that this is something that they've been working to resolve, that the government has implemented reforms that are going to make it easier for you to get your discharge status upgraded if you've been in this situation. So it's kind of an uphill battle, but something that they've recognized more and more is something that they need to resolve. All right, so there are 5 main categories of discharge statuses, and if you've served or you have a family member who's in the military, this is going to be probably really basic for you, and I apologize, but for people who haven't or don't have that connection, so there is a sixth category that I didn't include on this chart, which is uncharacterized. An uncharacterized discharge is just you left the military after your training or after less than 6 months, so you weren't really there for the full amount of time to get a one of these categories. So, and these categories are listed on the DD 214, which is the official paper that you get when you leave the military. When you retire from active duty, that's your certificate of release, your certificate of discharge is called the DD 214. And the two kind of important pieces of information that are going to be on your DD 214 are the character of service, which are these 5 categories, and the narrative reason for separation, which is just a short explanation of why you are separated from the military. So the most common category, the one that most people receive, and the highest category of discharge is honorable. That's the majority of service members are discharged honorably. And then the category below that, general under honorable, you serve faithfully despite issues like minor disciplinary problems, certain failures during training that were not severe, but that were not quite up to the standard of an honorable discharge. So, I mean, and you can face issues even with a general discharge with getting certain types of benefits. So it is, there are some things that if you have anything less than honorable, it's going to be harder to obtain. But the category below that, other than honorable, is where you start getting into kind of major bars to veterans benefits. That's a category that involves patterns of misconduct or at least one more serious infraction. And so that's considered an administrative dismissal. Everything honorable, general, uncategorized, and other than honorable, those are all administrative dismissals. The 2 below it, those are considered punitive dismissals or punitive discharge. And so those are much more serious. Excuse me. Below other than honorable, you have a bad conduct discharge, which is what its name implies. It's a punitive discharge based on a serious offense. You had a DUI, went AWOL for an extended period, were drunk on duty, that sort of thing. And then the lowest category is a dishonorable discharge. And that's when you've been court-martialed, you've been convicted of a crime that involves prison time. So it's the lowest, the worst of the discharge categories. And so again, you have this category below it, you have the narrative reason for separation, which could be like the descriptions here that you were abusing alcohol or had a pattern of misconduct. That's going to be what's listed as the narrative reason. All right, so the importance of the discharge status kind of to your life once you're separated from the military. I think probably the one important thing that sometimes gets discounted here because it's not a hard and fast statistic or a number is the fact that there's a lot of stigma and shame in the military community and in the civilian community kind of at large with being discharged other than honorably, with feeling like, you know, it's like you served your country, you did your role in the military, and then you've been discharged in a way that's not considered honorable, and that can be really hard. And you want to kind of get that recognition for your service. And that's a real kind of thing that can follow you around like psychologically. But beyond that, there are just a ton of problems that plague former service members who are discharged with bad paper. So one example is that bad paper discharge can make you ineligible for certain VA benefits, which includes things like mental health care and treatment. And so there are very high suicide rates amongst veterans who are discharged for misconduct. It's about double the suicide rate for those who are honorably discharged. And the rate of suicide for US military and veterans is just astonishingly high. About 20 per day throughout the United States die by suicide. In some categories, veteran suicides are between 2 and 10 times higher than the non-veteran population. And what we're seeing more and more is that, especially in the youngest category of veterans, you see these deaths by suicide attributed to traumatic brain injuries or to PTSD or both. So you have both those factors. You have that you're more likely to have mental health issues and feel suicidal if you have a TBI, and then you're also less likely to get help because you were other than honorably discharged because of your TBI and you don't have access to those services, which is just absolutely a vicious cycle. For similar reasons, you see these increased rates of homelessness and incarceration. Veterans with bad paper discharge are 7 times more likely to be homeless. And that can be, if you look at traumatic brain injury, you might have certain behaviors that make it hard to hold down a job, to hold down housing. And then because you have a bad paper discharge, you're less likely to have those benefits where the VA can help you find housing, can help you find a job, can help keep you from becoming homeless. And then with the incarceration rates, again, you might be more likely to to have behavior that could lead to getting arrested. And then once you're arrested, you're not going to have access to the veteran treatments courts, which are the diversion courts that can get you, instead of being incarcerated, can get you into treatment for mental health, for substance abuse, et cetera. If you don't have a honorable or a good paper discharge, you're going to find it harder to get treatment while you're incarcerated. And you're not going to have as much access to the reentry assistance kind of services. So it's really a pervasive problem that's happening across society for veterans who have not been discharged honorably. And you can run into these questions about your discharge status in a lot of places, right? It's when you go to the VA hospital, when you're applying for VA benefits, employers who give preference to veterans, they'll ask to see your DD-214. And if they see that you have a bad paper discharge, that's going to be harder for you. So all of these reasons are just kind of a way that society has created this uphill battle for people who kind of need access to these resources the most. All right, so the good news here is that you do have the right to appeal a discharge that was less than honorable. And I'm going to get into some kind of like specific terms here, but first I just wanted to distinguish between discharge upgrades and character of discharge review, because you might have heard those two terms and might not know kind of what the difference is. So for a discharge upgrade, that's going to be through the Discharge Review Board for your branch, or through the Board for Correction of Military Records for your branch. So you would apply, and that's through the Department of Defense. That's who handles the discharge upgrades. And that changes what's on your DD-214. It'll change the reason and the status. The VA handles character of discharge determinations, and those are different. Basically with those, you can get access to benefits if you have bad paper, but it's not going to change the actual status. So it's still really important to apply for this if you don't have access to VA benefits. It's faster, it's more efficient usually than applying for a full discharge upgrade. You can also do them simultaneously. And it would be similar to kind of the case you build if you're applying for a discharge upgrade. You would need to show, again, assuming this is because of your TBI, you would want to show that you were discharged for reasons that were related to your injury. And when you apply for the VA benefits, then they'll kind of review your record and determine if your service was what's considered honorable for VA purposes. And then you'll be able to have access to the benefits despite your, I live in Brooklyn. I'm sorry, that is going on outside my window, but it'll pass. Apologies. Right, so they'll review that and then they will hopefully give you access to those benefits while you're still waiting for your actual discharge upgrade to be heard. All right, great. All right, so going back to the discharge upgrades themselves. So this is all through the Department of Defense, and there are two different boards. There's the Discharge Review Board, and there's the Board for Correction of Military Records, and each of those will be within your respective branch if you are Army, Navy, etc. So the Discharge Review Board, these are composed of 5 officers from the branch of service involved, and it can change both the discharge status on your DD-214 and the narrative reason for discharge. It can only change a discharge, not a general court-martial. There's a 15-year statute of limitations for applying for the Discharge Review Board. So it's a pretty generous time frame. So yeah, 15 years from the time that you were discharged. You would apply using Form 293. And what you're going to need to show in this hearing is you're going to need to show that the military made an error. And there are 2 categories of errors, impropriety or inequity. Impropriety is just, did they fail to follow their own rules when they discharged you the way they did? And then inequity would be, did they discharge you in a way that was unfair given the circumstances? If the totality of your service was that you were honorable and honest and forthright and a good service member, but you had these few errors and mistakes, then they would want to say it might have been inequitable to discharge you in a way that didn't allow you to be considered a veteran for these purposes. And then you have the Board for Correction of Records, and it has a lot more power than the discharge review boards. Basically, so it's composed of civilian members of the respective departments who are appointed by the secretary of the department, so by the kind of highest level of that department. And they can do everything that a discharge review board can do, but they can also do more. So they can change anything that's on your discharge documents, including if you had been court-martialed. They can reinstate you into the military, which the discharge review boards cannot do. They can change the narrative reason to or from medical retirement, which is a category, which is something that the discharge review boards cannot do. They can make changes to your service record and to your medical record. And they can also review a denial from the discharge review board. There's a 3-year statute of limitations before you can to be heard by the Board for Correction of Records, but they can hear any case in the interest of justice. So if you have a compelling reason and are outside the 3-year statute of limitations, you might still be able to appear before the Board for Correction of Records. You would apply using Form 149. And what you need to show here is evidence of error or injustice. One important thing to note here is that if you can get the remedy you're seeking from the Discharge Review Board, then you need to go to them first. If it's something like you want to get your status changed from other than honorable up to general or honorable, but there's not a court martial involved, then you would want to go to the Discharge Review Board first. And if they then reject your appeal, then you can go to the Board for Correction of Records and they can review that. So what your application is going to look like, and I'll get into this a little bit later with the actual process of these hearings, but the application is going to include a cover letter, a personal statement, relevant service records, relevant medical records, and then if you have a TBI or a mental health diagnosis, you're going to need records to demonstrate that from your doctor, from the military hospital or your civilian doctor, and then a timeline of kind of the major events leading up to your injury, leading up to your discharge, and what happened after, kind of evidence of good character and what you've been doing in the community since your discharge. Have you been seeking help for a substance abuse issue or a mental health issue? That shows that you're kind of acting in a way that's proactive and positive and demonstrates that you are kind of resolving these issues that led to your discharge. All right, so I'm going to get into the CURTA memo, which is something that's basically provides the guideline for how these discharge upgrades work for people specifically with TBI who are applying for an upgrade. I want to talk, so first of all, what liberal consideration means, because it is kind of a specific term. Basically what that means is the board needs to consider all of your evidence, including the testimony from your family and friends, instead of just looking at your medical records. And it also means that they need to look at your brain injury symptoms as mitigating factors for your status instead of seeing your behavior as kind of willful misconduct, right? And basically, if they're giving their liberal consideration to your application, they are going, they're going to want to look favorably upon, they want to give you the best chance that you have, right? Like look favorably upon your situation, take into account what your friends are saying, what your family is saying, and what you are saying about why this happened. So before I get into the details of CURTA, I wanted to talk about some other recent Department of Defense memoranda that are that are going to be relevant here. And each of these memos, it's named for the general who drafted it basically, or who it was promulgated under. So the Hagel memo, that's 2014. So what this did was it waived the statute of limitations at the Board for Correction of Records for cases that were related to PTSD. And it gave liberal consideration for PTSD if these symptoms are in your service records or in your treatment records. Basically, even if you didn't have the diagnosis at the time, if you had treatment that if you had symptoms that looked like PTSD, they should take that into account. And they would give special consideration for VA determinations of service-related PTSD, liberal consideration for civilian provider diagnoses, and the potential for mitigating misconduct by showing that you had these symptoms, right? And then the Carson memo in 2016, it's notable because it mentioned TBI as a condition related to PTSD, and basically showing that the board should consider TBI in the same way, that it could mitigate your misconduct and that it is relevant to getting your status upgraded. And so the CURTA memo, which we have here, it's granting you liberal consideration in your appeal case if you were discharged for any of these 3 reasons: traumatic brain injury, mental health conditions, including PTSD, and being the victim or survivor of a sexual assault or sexual harassment while serving. And the board is going to consider 4 factors. And that's first, if you have a condition or experience that may excuse or mitigate the discharge. So in this case, it would be, do you have a TBI diagnosis? Second, if the condition existed or the experience occurred during your military service. So you sustained your TBI during service, and that could be in combat or not in combat. It could also be if your TBI was worsened, if you had concussions prior to serving and then had more concussions and that caused kind of the more serious symptoms, that would still count as well. So it doesn't have to be that you never had a TBI prior to serving. 3 is if the condition or experience actually excuses or mitigates the discharge. So was your behavior caused by your TBI? And then, or does it in some way mitigate your responsibility for the behavior? It doesn't have to be exclusively caused by, but like you look at that and think, oh, I wouldn't have behaved that way if I hadn't had the TBI. And then 4 is if the condition or experience outweighs the reason for discharge. So can they look at this and say, the person behaved this way because of their TBI, and therefore we should really upgrade their status to better reflect who they are and how they served generally. One other final memo that I want to bring up is from the year after the CURTA memo. It's called the Wilkie memo. And its purpose was kind of just to clarify for all of these appeals cases, because there have been a lot of them, what the standard are as far as inequity, injustice, and clemency, and to allow the boards to kind of be more fair and ensure this fundamental fairness in their consideration. Because as you've seen, there's a lot of really kind of nebulous subjective factors where they can look and say, oh, was this person honorable or not? And so this kind of lets them look at it more with criteria for like specific factors for weighing the mitigating value of what happened and your conduct, your achievements. There's a big emphasis in the Wilkie memo on second chances, and specifically includes post-service conduct and achievements. So that's great if you've left the service and then have kind of done things that'll they'll show that you're serious kind of about your treatment and about your work in the community and your life in the community, and they can look at that in determining whether to grant an upgrade. So not just what happened in your past, but what's happening now and what can happen in your future. All right, so this is something, the New York Restoration of Honor Act, which is not related to the discharge upgrades on the federal level, but is still really important to know about if you're in New York, which you guys are. This was passed really recently. This was a 2019 piece of legislation, and they just started hearing cases in November, this past November 2020. So it's very new. And so basically with this new law, you can apply to have your benefits restored, your New York State benefits. So there are a bunch of New York State specific veterans benefits that are not related again to your federal kind of VA benefits, but are still really important. There are veteran specific tuition awards, public housing benefits, veterans property tax exemptions. You can be buried in a state veteran cemetery, various kinds of fees that are waived, things as specific as like parking at the SUNY and CUNY campuses, or hunting and fishing licenses, which are all things that are really going to add up, though, especially if you look at things like the tuition and the housing. It's all adding up to a better quality of life if you're able to access these services and programs and discounts and things like that. So under this law, you can apply to have your benefits restored if you were denied an honorable discharge due to 5 categories: sexual orientation, gender identity, military sexual trauma, traumatic brain injury, or post-traumatic stress disorder. So you can see kind of some overlap between that and between what was in the CURTA memo and these other recent memos that are explaining reasons that you should be able to have your status upgraded. So how the Restoration of Honor Act works. Basically, there is an application that you can access online, and that is, it's written on the screen, but I'll read it out for you as well. It's at inclusion@veterans.ny.gov. So you fill that out, you submit your military personnel file, you submit a personal statement, and in that statement, you're going to describe why the assigned character of service was unjust and why an upgrade is appropriate, similar to what you'd be doing if you were applying for a discharge status upgrade with the DoD or for a character of service upgrade with the VA. And then if you have a service-connected rating for your disability from the VA, then definitely include that. So some more specific things you'll need if you're applying based on a TBI or based on a PTSD diagnosis, not for the sexual orientation or gender identity ones because it's not applicable, but you would need to show evidence of your diagnosis, and that should be from a Veterans Health Administration doctor or a provider affiliated with VHA. And then you would need to show evidence from that doctor or from that affiliated provider that your disability occurred or worsened during your military service. So that kind of goes back to what I was saying earlier, where you don't have to show that you never had a TBI before, just that your injury was worsened during service or that it occurred during service. And then if you have, so you also need a written explanation of how your TBI led to your less than honorable discharge. That's kind of be the fundamental why this happened and why it was the result of my injury and not of willful misconduct. And then again, if you do have the service-connected rating for your disability for your TBI, then include that as well. All right, so why would you need kind of an advocate or an attorney to help you with this process, right? So there are two types of reviews that I'm going to go over, and these are again for when you're petitioning the Discharge Review Board or the Board for Correction of Records. There's one called a documentary record review, and another one that's called the personal appearance hearing. And each of those are basically what they sound like. A documentary record review, you submit a packet of documents which are similar to what we've described earlier, your medical records, your service records, your reasoning why this happened and why it was unfair. And then a personal appearance hearing is going to be more like a court proceeding. You would go in person to the office, or I think now probably via Zoom or via video chat, depending on how they're operating. I actually don't know how they've changed the system since COVID. But you would go, you would appear before this board, and you would explain, you would state your case. So for that, it makes sense and is helpful to have an advocate or an attorney there who's handled these cases before, who knows what looks most favorable to these boards and what's going to be the most helpful in your specific case. But even if you're not doing the personal appearance hearing, it does help to have an advocate or an attorney to look over your papers to help you craft your case in writing and show what needs to be included, what doesn't need to be included, how best to frame your statement to reflect what really happened and why it is important that you get this upgrade. So also just to note that it's recommended that you apply for a documentary record review first if you're going to be doing this. And then if you don't get the full relief that you requested, then you can go to the personal appearance hearing. That doesn't work in reverse. You can't go to a personal appearance hearing first and then go back and request a documentary record review. So if you're going to request a personal appearance hearing and you don't want the record review, you should know that you can't then go back and do that. So if you want to be able to get your records reviewed first, do that first, and then you'll have the hearing. So there are these organizations that I've listed on the slide, and I can send around the PowerPoint after this as well. These are resources, these are legal clinics, some run through law schools, others who are projects run and staffed by attorneys. And what these do is they provide advice and counsel and advocacy and sometimes direct representation in these hearings to make sure you have the best case possible when you're trying to get your discharge status upgraded. These are all great programs. There are many more across the country as well. So there is, it's a daunting task, as I'm sure you can imagine from seeing these slides and these descriptions. It's easy to get lost in the details, and you want to make sure that you have the best possible case, because this is really important for getting access to so many benefits and to so many just better quality of life that you can get from having your status upgraded. All right, and so that's the end of the substantive portion of this presentation. I will have a lot of time at the end for Q&A and for discussion, which is great. So I will conclude the presentation now and turn it over to my future self and to the group at the presentation at the Brain Injury Association. Thank you guys so much.